Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillahi rabbil alamin wa thanau lillahi wa salatu wa salam ala rasulillahi sallallahu alaihi wasallam. It's my great pleasure for us to be present here today at this very auspicious auditorium of one of the most the best universities in Kenya that I know of. And I'd like us to appreciate the effort of YMA, the Association of Muslims universities and colleges in Kenya, and all the other partners who have made this occasion successful. Your attendance today has greatly encouraged me and our institution, and on behalf of the Muslims of Kenya. So we are going to talk about the Kadhi'S court. The focus is on the youth, especially the university students, as well as the high school students who very soon are going to become university students. Among us here are scholars, learners, and sheikhs. We are very privileged to have you with us. I know there are more knowledgeable people who have immense knowledge on this topic that we can share, but on this day, that duty falls on me. We have our esteemed, distinguished scholar, Dr. Abdulhalim, who we've done a lot of works together. He teaches Islamic law, he's a scholar, a researcher in Islamic law, and many others in this field. The importance first, before we delve into this topic, why should we even understand the Kadhi'S court as university students and Muslim youths in Kenya? To put that into perspective is to know the geography of the Muslim world, that there are so many Muslims in other parts of this continent and even other parts of the world who will do anything they could do just to have even a piece of the legislations that we do have, to enjoy the rights that we do enjoy in Kenya from time immemorial. I was privileged to attend an event at the Riyadh, Alhaajartvkenya, where we had so many other students from Africa in general, but students also with that from other regions, Asia, Malaysia, and Indonesia, who come to study there to specialize on the judgeship in Islamic courts. Countries that have immense history and expertise and scholarship in Islamic law, but do lack the institution of the Kadhi'S court, and they are crying for us. A country like Mali, a country like Senegal, who have produced so many scholars, have written so many books, but their laws do not allow the establishment of the Kadhi'S courts, and they just have to follow the other normal courts like the other ones. And they are surprised when in Kenya we have a court that is established under the constitution. And those are majority Muslim countries. So we must be very appreciative, very thankful and grateful to Allah the Almighty for this occasion, so that we actually cherish, protect, and advance this institution that we have in Kenya. I'm going to talk things, probably you know them. We're going to talk some history. We're going to talk about the challenges we had into the changes into the constitution. We are going to talk about the jurisdiction of the Kadhi'S court and the challenges therein. What exactly do we deal with in the Kadhi'S court? Is it limited or is it extensive according to how you look at it? And probably how the more current challenges that we have. And then how is it relevant? The Kadhi'S court in our day-to-day life, how does it have any effect in our day-to-day lives? And what probably is our role eventually that we can do to chip in to protect, advance this very important institution for the Kadhi'S court in Kenya. In Kenya, the Kadhi'S court is one of, you can change the, it's one of the oldest, I always say, institution of law in Kenya. Even before the colonists came, but even before the Usaidids came, the Arabs came to Kenya, there already existed in the coastal strip of Kenya some form of a legal system, as it is shown by history. Ibn Battuta in Al-Rahal al-Maghribi, the Maghribi geographic person who just tried to roam around the world to look and record the new places of the world. He records that in the 14th century, he came to the coast of Kenya and he found that there already existed Muslims and there existed mosques, and in those mosques, the imams also acted as spaces for legal disputes resolution. So even as early as the 1400s, there already existed that even before the Sayyid came to Kenya, or Sayyid al-Baragash, as we are going to see. In those, the same, it is recorded in Al-Maqasid al-Hasana في بيان كثير من الأحاديث المشتهرة على ألسنة الناس لإمام شمس الدين السخاوي. He says that Al-Maqrizi in 1436 is in Mecca during the Hajj pilgrimage. And at that time, the Qadi of Lamu, Sheikh Muhammad bin Ishaq bin Muhammad, was performing pilgrimage in Mecca in 1436, as early as that time. So we find that there was already a Qadi of Lamu who had gone in Mecca to perform Hajj, and Al-Maqrizi was able to record that in that very good book of his. And we can see that then before probably even the 1430s, as early as wherever Muslims were there, and we know that Muslims were present at the coastal strip as early as when the Prophet Muhammad ﷺ himself was alive. So there is that possibility that the institution of the Qadis is old as even while the Prophet Muhammad ﷺ was here. But when the sultans of Oman came to Kenya and the coastal strip and Zanzibar, especially from Somalia, Mafia, all the way to the South Islands of Mafia, Zanzibar and Pemba Islands, all those even up to Mozambique, some of those areas were under the Sultan, Said. He established the Kadhi'S court. They became more organized and having more powers. Rather than working from a mosque, then they had more special powers. When Sultan al-Barghash came around 1878 to 1888, that was the time that the sultanates were becoming weak. So they tried to give it up to the British through a company. Even the British government itself had not come yet to the coast to take it. There was a company, East African company. So they entered an agreement with this one, and so that they can administer the coastal strip on their behalf. And when the government of Britain eventually took over the company, they entered a charter with that company. And in that charter, at Articles 11 and 12, it led to the protection of religion, customs, and laws of the peoples of the territories where Muslims were predominant, and those were what was formerly known as the protectorates. This shows us that as early as even when the colonists came, when the rules shifted from the Sultanate to the British, the protection of the Islamic Kadhi'S courts, Islamic legal system, and Islamic administration were being preserved through the laws that were being enacted through treaties and agreements. So the British government, East African Company, and the British Protectorate declared the coastal strip as a British protectorate, and that protectorate preserved also initially the powers of the Islamic courts or the Kadhi'S courts to be able to function. Then there was the period when Kenya wanted to get independence. And then there was the issue, what will happen to the coastal strip, which was never colonized, and the people were referred to as subjects of the Sultan. And these are a charter that protects them. What is going to happen? So James Robertson did in the sessional paper number 61 of 1961, did a research and was given time to propose what should happen to the coastal strip. Through that sessional paper, he proposed that the best is to have the coastal strip together, because of so many other issues, together with Kenya, but fundamentally protecting not only the Kadhi'S court, but also the institutions of learning of the Muslims, also protecting the administration of the people, especially of the coast. So they entered an agreement between Duncan Sandys, representing the government of the UK, the Said Jamshid, representing the Sultanate, Jomo Kenyatta, representing Kenya, and Sheikh Mohammed Shamte, representing Zanzibar, that they are going to surrender the coastal strip to Kenya, provided they are going to protect those Muslims. And that agreement is a treaty. It's an international treaty that specifically provides in our context, for the Kadhi'S court jurisdiction and the Kadhi'S court establishment, together with other things. It was in form of letters dated 5th October 1963. You can scroll. I have my own screens for them to follow. Yeah. There are so many. Yeah. Continue following. We are in 1963 Kenyatta-Shamte agreement. So in that agreement, it was in form of letters, which states, I have the honor to propose the letter and you reply thereof shall constitute an agreement between our two governments. That is Jomo Kenyatta telling Shamte. And Shamte replied, I have the honor to confirm the contents of your letter and to accept your proposal that your letter and reply, this reply shall constitute an agreement. So that is an international agreement between Zanzibar and Kenya, between two presidents of two independent countries. So that agreement is an international treaty. An international treaty is superior to even the constitution of Kenya. It cannot be unilaterally abrogated by one party without being checked through the international avenues. In that agreement, the main provisions are that the people, number one, the free exercise of any creed or religion, and in particular, His Highness's subjects who are of Muslim faith and their descendants will at all times be accorded of complete freedom of worship and preservation of the religious buildings and institutions. And the jurisdiction of the Kadhi'S and all other Kadhi'S will extend to the determination of questions of Muslim law relating to personal status, for example, marriage, divorce, and inheritance in proceedings, which all parties profess the Muslim religion. And thirdly, administrative offices in predominantly Muslim areas shall, as far as reasonably practicable, be themselves Muslims. So these is the contents found in the letters between Jomo Kenyatta and Shamte, and they talk about the freedom of worship for the Muslims, and administrative officers in Muslim predominant regions shall, as far as practicable, be to Muslims. But most importantly is the jurisdiction of the Kadhi'S court. You see, the 1963 Constitution, the provisions of our jurisdiction is coming from this treaty. So whenever you have problems in interpretation, disputes in interpretations of the Constitution, the fallback should be this international treaty. We've been having challenges in interpretations of the Constitution. Here it is used to extend. It is used in a positive manner. In the current Constitution is used, and the jurisdiction of the Kadhi'S court has been problematic in defining our jurisdiction. It is very clearly and explicitly explained in the treaty between Shamte and Jomo Kenyatta. Personal status, for example, marriage, divorce, and inheritance, meaning all these fall in there, and these are just examples, and they are not limited to these. We can also do other parts, including personal status, which we are going to discuss more if time allows. So I've discussed that the treaty, at the time when the constitution was being changed, we are coming to a new constitution. That was another phase. There was an attempt to try to remove it. According to the laws of treaties, you cannot, even through a constitution of Kenya, remove the provision of an international treaty. That's how it is problematic. Fortunately, you are able to preserve it in the constitution, albeit with some minor problems, as we're going to further discuss in this presentation. So in the old constitution, the provisions that established the Kadhi'S court was section 66(1), and the provisions that gave its jurisdiction was section 66(5). That gave us the provision. Go to the slide with the Kadhi'S, chief Kadhi'S of Kenya. Yeah, there. So those are the chief Kadhi'S of Kenya since inception. Sheikh Abdulrahman Sayyid Ahmad al-Sagaf was the first chief Kadhi in 1897. It was just before, even before independence, there was this first chief Kadhi. Then Sheikh Muhammad Umar Bakor, Sheikh Suleiman Al-Khamis Said Al-Mazrui, Sheikh Al-Amin Ali bin Nafi Al-Mazrui, Sheikh Said Ali Jamal Al-Layl Al-Badawi, Sheikh Muhammad Qasim bin Rashid Al-Mazrui, Sheikh Abdullah Saleh Al-Farsi. From these ones, at least when we were very small children, we were able to see Sheikh Saleh Al-Farsi, Sheikh Nasir Muhammad Al-Nahdi. We were privileged to see him, to talk to him, to seek his advice. And Sheikh Muhammad Qasim Al-Mazuri worked under him, and Sheikh Ahmed Hussein Al-Muhdar. So these are the chief Kadhi'S. But the Kadhi'S in Kenya are so many, and Dr. Abdulhalim Hashim is working on research to have all of them and their history. And Sheikh Saleh Al-Farthi has written about the chief Kadhi'S, what they were doing, who are their students, who are their teachers, and so on and so forth. The Kadhi'S court, there was a time during 2007, just after the disputed 2007 national election, there was a problem. So one part of the problem, how it was going to be solved, was that we had to change this constitution. Then there was formed the CKRC, Constitution of Kenya Review in 2008. And this one provided for a roadmap and the legal framework to a new constitution. And there were so many work that were done. There were several drafts: the Boma's draft, the Wako draft, the Kilifi draft, the harmonized draft, the reviewed harmonized draft, and then the proposed constitution. So these were many different draft documents that were trying to change the constitution. And we know, as relates to our institution, the Kadhi'S court is already there in section 66. But now, when you are doing the new constitution, under the Guy Commission, he tried to take views from the people themselves. And then they are going to go to the constitutional convention at the Bomas. And that's where people are then are going to brainstorm. And there were a lot of problems, and there were a lot of challenges facing the Kadhi'S court. There were many attempts to actually remove it. And that part of history is now past us, but it is important for law students and for all the Muslims to be able to understand and to appreciate. We will not talk, due to time constraints, a lot on that part, but suffice to say that some of the people who assisted the Kadhi'S court to remain were probably not even Muslims themselves. The Guy draft, the Kenyans wanted a Kadhi that is superior, even before the 1963 constitution. They wanted it to have more powers, more jurisdiction, to hear not only personal status matters, but to also hear business matters, commercial matters, small claims matters. And also they had proposed in the Guy draft that there be the appellate Kadhi'S court. Why, after a person is dissatisfied with the decision of a Kadhi, then the decision goes to the High Court, where the final decision is made by a judge who is not a Muslim, not conversant with Islamic law. So the proposal was, in that the first draft, the Guy draft, that we should have an appellate Kadhi'S court. But that attempt failed because at the Bomas Convention, there could be no agreement. Then the matter was taken to the politicians, went to Naivasha and did the harmonized draft, and then they went again, did the revised harmonized draft, and then they went to Kilifi and did the Wako draft that was subjected to the banana and orange that failed, and then they came back to the committee of experts and did the final dispute and the final draft that was eventually passed in the 4th of August 2010 Constitution. The final one in that Constitution, the current one, was mainly to preserve the same one, but it is weakened in some case by adding and to submit to the jurisdiction of the Kadhi'S court. So they retained essentially as it was in the 1963 Constitution, without limiting it geographically so that it is applicable throughout the boundaries of the current Kenya, but it was limited now to another aspect where all parties profess the Muslim faith and submit to the jurisdiction. That, in my view, was an addition that was uncalled for. Nobody had called for it. The people had not given their opinions on that, but we don't know how it came in about. And it is one of the very problematic sub-articles of the Constitution, and we are probably going to explain more about that. So the Constitution was passed, fortunately, even with the problems, but with 68.5%, the Constitution was passed. Why they were opposing it, why the Muslims were supporting it, that is another discussion. The contents are in my presentation, but also we will not delve too much into it, except that most of the issues or most of the problems, actually, I must say, is why this event is important. When, as a Muslim, you don't understand the importance of the functions of the Kadhi'S, then you yourself, you can be participating in weakening it, even to the extent of removing it. You don't care about it. The people who actually increased that sub-article to limit the jurisdiction of the Kadhi'S court, you'll be surprised to know they're actually Muslim. The chairperson of this committee was a Muslim legal expert, a lawyer, and he found no problem without consultations, and that was put there. And the effect is that any person who thinks his case is weak, then he can say, I don't submit. And it just goes like that and frustrates the other party. As we are going to see, there are so many other judgments that are going to. But that is very dangerous to any Muslim to do, and that is not helpful. But if you understand the impact, you will do anything to do it. And some of the scholars, not Muslim scholars, who've written papers and research papers, were the ones who assisted the Muslims, together with Akina Lithome and the others, to be able to preserve the Kadhi'S courts. But ourselves, our brothers and sisters, without understanding the importance of this institution, have in a way been contributing to weakening or to damaging the reputation of the Kadhi'S court. And that's why it's important to understand the importance. We go to the legal framework. A Kadhi court is not a kangaroo court, as some lawyers will want us to believe. It is based in the Constitution, and the jurisdiction of any court is derived from the Constitution or statute. Statutes are laws of Kenya, the acts of parliament. And there are about 9 acts of parliament that support the Kadhi'S court. In their provisions, they have donated and given powers to the Kadhi'S court to be able to hear matters specific to Islamic law. So there's Article 169.1 establishes the Kadhi'S court. Article 170, sub-article 5, gives the jurisdiction. As Section 5 of the Kadhi'S Court Act, Cap 11, Laws of Kenya. The Marriage Act number 4, relating to marriages. Our marriages are recognized under the marriage laws of Kenya. They're all consolidated in the Marriage Act, and they are recognized that they're not different from the other marriages that we done. You don't have to go to the Attorney General to have your marriage be recognized. That marriage is already recognized under the Act. The Muslim marriage rules, that gives specific rules to the operationalization of the marriage, the rules of the Marriage Act. Also, there are other rules. And then we have the Kadhi'S Court rules of practice and procedure that Dr. Abdulhalim helped us to formulate. For many years, there's the substantive law, there's the act that just gives us the jurisdiction, but then there's this applicable law. The applicable law in the Kadhi'S courts is the Islamic law, Islamic family law. Where do we get it? We find it in the Kutub al-Fiqh, in the Quran and Sunnah. So essentially, Islamic law is being applied. Islamic family law, we just apply the Quran and Sunnah. We go where there are small details in Al-Minhaj and their translation and expound and the exegesis of those books and the other fiqhs that are there by the ulamas that have done. That is substantive law. In marriage, divorce, and inheritance, and custody, and waqf, and hiba, all those are according to Islamic law. So Islamic law is being applied. And that is not a small thing. It is not an insignificant thing. It is a very a big deal to Muslims that you can apply Islamic law in your life according to Allah subhanahu wa ta'ala and Sunnah of the Prophet Muhammad sallallahu alayhi wa sallam. But then there is the Qanun al-Murafa'at, as they say in Arabic, the laws of procedure. For many years, since 1969 until very recently in 2020, we've been using the Civil Procedure Rules, Civil Procedure Act, Cap 21, Laws of Kenya, and the Civil Procedure Rules, which are very complex. They are not relevant to us. But the Kadhi'S Court Act said the rules of procedure should be rules of procedure of Islamic law. The rules of evidence in the Kadhi'S Court should be Islamic laws of evidence. But we had no rules of procedure specific for the Kadhi'S Court until 2020 when we got these rules. And then the Waqf Act number 8 of 2022 gave that jurisdiction to hear matters of a waqf. Before, you had to go to the High Court. An issue of waqf cannot be heard by the Kadhi'S Court. But now, when you go to the High Court, they will return those issues, those cases regarding waqf to be heard by the Kadhi'S Court. And then there's the Matrimonial Property Act, Section 3, the MPA number 49 of 2013, that when parties have divorced, two spouses have divorced, the laws applicable is MPA, but for Muslims, then they can either be heard by the magistrate court or be heard by the Kadhi'S Court under Section 3. And there are so many judgments regarding that. So we've talked about the history, we've talked about the challenges, we've talked about the legal framework. Now, I'll go to the jurisdiction, which is important in my view, and we have very limited time. The jurisdiction of Kadhi'S Court, you see if you remember, you followed in the Shamti agreement, the term used was to extend, and personal status was very clearly defined. In the current constitution, it is not clearly defined. Personal status is actually not defined at all. And it says that the jurisdiction of the Kadhi'S Court shall be limited to. So the focus is on limitation of the jurisdiction, personal status, marriage, divorce, inheritance, provided that all parties are Muslims and all parties submit to the jurisdiction of the court. So here there are apostrophes. Personal status, apostrophe. My observation is that these are different things. Personal status is different from marriage, it's different from divorce, it's different from inheritance. So it has to be given its meaning, and in the meaning, according to Islamic law, it's very clear. Those are issues, any other matter pertaining from the life of a Muslim, from the time he's born to the time he's dying. All those matters are personal status. So the children issue is a personal status. The issue of custody is a personal status matter. The issue if a person wants to be buried is a personal status matter. And so many other issues that people have been trying to take it out, and there are cases of that. So that is what you are saying about the issue of personal status. the relevance of the Kadhi'S court today is that this depends on that dichotomy between extension and limitation. It is very relevant today, probably more than any other time, for a robust advancement of the Kadhi'S court. You see it, your personal life from the moment you're born to the moment you died is controlled by Sharia. It's not enough that you pray and you call yourself a Muslim, but you don't want to be controlled, or in case of dispute on your affairs of marriage, divorce, custody, you don't want to be controlled by Sharia. Then you're not true Muslim. You say, I don't want to submit, I don't want this decision. Then you're not a fully Muslim. Or decision that is all the Kadhi'S have said that, ulamas have said that. You say, no, I don't want to. This decision of inheritance is not fine. The decision of work is not fine. So Islam is not just about going to Hajj, making prayers, fast, so on, but actually exactly how you live your day, how you live with your wife and children, and that's all about this, how it is important and it is relevant to this day, so that you can appreciate and be able to support this Kadhi'S court. Also, the stability of any community starts from the family, and that is starts with the marriage, how you choose your wife, how you are going to prosper, and then how you are going to take care of those children, whether you are with your wife or whether there's a divorce. And in the event you're divorced or your parents are deceased, how that wealth is going to be distributed. So that is important, and that shows the relevance of the Muslims, of this Kadhi'S court, where whenever there's a dispute, then that's where this one will go to fall. So we want to preserve the family units, so that the families, in cases of divorce, the children are taken care of, and they don't become chokoras. They are going to become stable citizens, and we encourage marital education and so on and so forth. But more importantly, that we have a very strong and stable and empowered and probably rich Muslim community. And that goes through the inheritance. When we resolve inheritance disputes, we are unlocking potential. A lot of money that are hindered, that are blocked from operation because of the dispute. We have a case that probably is going on for 20 years in the courts. That money is not properly used, or it's being used by one person and the others are very poor, while that money should have been unblocked. Once you do a distribution, everybody gets his share, then you see they're going to be able to use that money and properly, and they're going to empower themselves. When only few people are going to use their money, only one person, the administrator and the family, for 10 years, 20 years, there's a dispute and it's not resolved, then that money just stays either unblocked or it's not properly used and leads to a lot of poverty in the community. So we unlock a lot of economic potential, but we also encourage families to be able to work together, even with others, to be able to further use their inheritance so that they can increase their wealth and make their community more. It promotes cohesion, and the Kadhi'S court is a symbol of unity among the Muslims. And the Kadhi'S court is very popular. It's very popular with the judiciary. It's one of the most expeditious in its resolution of parliament, of decisions. There have been consistent increase in the number of the cases recorded in our court, and the rate of, we call it the CCR, the case clearance rate, is very high, at 98.98% this year. We expect it to be more than 100%. That means the average time of disposal is actually about 5 days, 5 days sometimes, or 3 months at the most, the case is going to be resolved. And that's why a lot of people, it's very simple to approach the court in comparison to the other cases, the other courts, and also very fast in resolution of the case. So our role, the challenge I want to give to the students present here today, is to learn about this more. Today we are just giving you Kiswahili tunasema chachu ya kujua, so that you learn more about this institution, and for the law students to do research, and for the other Muslim stakeholders to organize such fora and many others that can educate and sensitize the Muslims on the importance of this very important institution in our life. The time has gone. There are so many other things I wanted to say to demonstrate the challenges we are having, legal, technical challenges that people, scholars in South Africa, where in Kenya we've been unable to protect ourselves. As a Kadhi, when you put a decision and then the High Court says you are overruled, this is quashed, it's set aside. But there are scholars like J.D. Mujuzi, professor in Western Cape, South Africa, who's written a paper criticizing the decisions of the High Court or Court of Appeal, who have probably told us that we are not right in our decisions. That is the work of the scholars here, who can do more research. When you find a decision that is not pursuant to Islamic law, then you can do more research and share it and publish it, like many other scholars who've done. Then that will be your contribution, part of the contribution you're doing. And lastly, do not take it very personal that you act, for example, of marriage or losing a case, and then you make the whole problem that the Kadhi'S court is bad because I've lost a case, because I was, for example, mishandled at the case. That is an individual case that has happened. I've seen an example of one person or two on Facebook, and then they're criticizing and generalizing a mistake and making it a very big issue when that is a very small issue. Somebody married, not according to Islamic law, and that decision of his, because of his love, or because of for satisfying the love he has for, let's say, 10 years, 5 years, but that has had an impact of changing the laws for Muslims in Kenya, probably for decades. That is a responsibility you have to take when you're marrying, when you're criticizing the Kadhi'S court and so forth. He married a person who was already married and not divorced, and then now he's dead. They go to court, and then they want the money, the wealth to be distributed. The court says you are not married, you are not entitled, and then they go to another court, say, how can you discriminate? This is the values of the constitution and so on. But the Rasul sallallahu alaihi wasallam said, any person who sleeps with another lady who, without marrying her, he is a prostitute, they cannot inherit each other. That is the Rasul who said. But because of your act and not following the Rasul, you've been able, through your act, indirectly to change the constitution. So it's not a very personal, individual choice that you are making. If that choice has ramifications to all the Muslims, subhanallah, that challenge is very, very big. You must say astaghfirullah, and we should pray for him. I don't know how he's going to make it before Allah subhanahu wa ta'ala. Maybe we'll engage in the question and answer session with more. Thank you very much for your attentive listening to us. I just hope I've been of a little benefit. Shukran lakum wa husnan. لستنسمعكم وجزاكم الله خير.